Hello and welcome to Runkle to the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Danielle Smith, the Premier of Alberta, has announced that she's going to be taking steps to protect Albertans who need to defend themselves in their home from home invasions. Now, she's been facing a number of criticisms over this. The first criticism is people who are sort of philosophically opposed to this. Either they don't really believe in self-defense, or they're concerned that this is going to lead to, tragedies or something else. I don't really share those views, but they're out there. Personally, I am concerned more about the fact that the police response times are, 10 minutes if you're in the city, and if you can get to 911 before you're actually under attack. And so I'm more concerned about the fact that really you have to defend yourself when there's a home invasion. There isn't really any other choice. However, there's another criticism that I do share, and that is that she really lacks the power to do what really needs to be done here. She is the premier of the province, so she wields provincial authority. But what needs to change here is the criminal code, and that's federal authority. She doesn't have the power to amend the criminal code, and any law she passes that contradicts the criminal code is very unlikely to be valid. She can't say, well, Alberta has more self-defense rights than anyone else, because she just doesn't have that authority. She lacks the power. So ultimately, this is something that really needs to be addressed by the federal government, and the current federal government doesn't seem likely to take steps to expand self-defense in any way. So, what can she do? Well, she is actually taking a step that is within her authority, and that is this. This is the Self-Defense Alberta Crown Prosecution Service Practice Protocol. So what she's doing is she's providing directions to Crown prosecutors as to how to approach these files. And you can see that right at the beginning here. It says effective November 28th. This practice protocol provides prosecutors with guidance and direction to assess cases that involve the law of self-defense, particularly those cases involving unauthorized entry to personal dwellings. So, Canadian law does allow for self-defense. The sort of guiding principle is that the force used must be reasonable in the circumstances. And in fact, the burden is on the prosecution to prove that the force used was not reasonable, assuming that there is at least a little bit of evidence to suggest that self-defense is a valid, issue. It's got to be put in issue. However, the problem is that when somebody is prosecuted and they have to go to trial, the trial process itself is incredibly damaging. It will likely cost tens of thousands of dollars. People might be incarcerated in the meantime, in which case, if you end up doing 3 months in jail while you're trying to get bail, it's very difficult to maintain your life. Your job is going to fire you. Your partner probably going to leave you. CPS is probably getting involved with your kids, or custody battles begin and end, and you end up with custody troubles and so forth. All of these end up being huge things. Your friends are unlikely to take your phone calls. You'll lose your place. All of these, if you're renting, well, you're going to be evicted, and your stuff is probably going into a dumpster. If you've got a mortgage, well, you're going to be missing payments, and they'll take steps there too. It is incredibly damaging to have these things happen. And even if you're not held in custody awaiting trial, you get bail, you're still going to be under restrictive conditions, and those conditions are likely to do things like disarm you, which might be a real concern if you've got people who are out there, trying to hurt you, and then the government says, well, because you defended yourself, we're going to take all of your weapons away, and you better hope that his friends don't come by because, hey, you don't have anything. It's going to be incredibly stressful and incredibly expensive. really, the process itself is highly punitive. So, what do we have here? Well, we've got this practice protocol, which essentially tells prosecutors a bit of how to do their job. And because the administration of the criminal justice system, the administration of all of this is within provincial authority, she can provide this sort of guidance. So, they note it also provides the following guidance: that prosecution for the use of reasonable force to defend oneself and/or others in one's home will generally not be in the public interest. This is because there is strong public interest in 1, preserving and protecting the safety and sanctity of personal dwellings, and in 2, protecting oneself and/or others, especially any children, elderly persons, or other vulnerable persons within the dwelling from people who intrude into that dwelling. Okay, now it summarizes the law here, and we're going to skip over a fair bit of the summary because it's not going to be the most sort of important aspect here. It's not at least the subject of this video. But they note that to proceed with the prosecution of a case in which self-defense is raised, the Crown bears the burden of proving, beyond a reasonable doubt, that the accused did not subjectively believe that force or a threat of force was being used against them or another person, or that the belief was not objectively reasonable, or that their actions were not for the purpose of defending or protecting themselves from another person from the use or threat of force, or the actions of the accused were not reasonable in the circumstances. And the reasonable in the circumstances is is the usual thing that gets argued here. Now, they also note, and there's an interesting focus on rural and remote areas here, because they say, if an incident occurs in a remote or rural location and self-defense is used, a prosecutor should consider as part of their analysis, 1, the nature of the location, and 2, any reduced or limited access to emergency services in the local area. If I were to get out my cell phone right now and call 911 and say, I am being murdered with an axe, and, I'm screaming for help and so forth, I would expect that the police could be here in 10 minutes. Faster than a pizza could be here, but not extensively faster. If I order food on Skip the Dishes, it might take about the same amount of time. So, but if I was, if I'm out in the woods, if I'm out in some rural area, farmlands and so forth, that response time might not be tens of minutes, it might be hours. And that is even for the most high priority calls. The I am being murdered right this second call might have a response time measured in hours. So at that point, what else are you supposed to do? When everybody says, oh, just call 911, well, 911 doesn't help you if it's going to be forever, right? So they also note self-defense in a personal dwelling. Prosecution for the use of reasonable force to defend oneself and/or others in one's home will generally not be in the public interest. When assessing the public interest in a case involving charges for the use of force by an accused responding to an intrusion or their personal dwelling, prosecutors must consider the following. So 1, there is a strong public interest in preserving and protecting the safety and sanctity of personal dwellings. This fundamental principle is reflected both in jurisprudence and legislation. And they have citations to both. We're not going to look through those, but they cite to both case law and legislation. There is a strong public interest in protecting oneself and/or others, especially any children, elderly persons, or vulnerable persons within the dwelling from people who intrude into that dwelling. This is something that often gets missed. If somebody breaks into a home, well, you might not just be protecting yourself. You might be protecting, your kids, grandparents, whatever. And that is something that really needs to be considered here. They note prosecutors must also consider important additional factors when assessing self-defense claims that arise where an accused alleges to have been responding to an intrusion of their personal dwelling. Where relevant to the facts of the case, the following factors will generally bolster a self-defense claim and weigh against an assessment that a prosecution is supported by the evidence. So they note First, it is generally unlikely that a person would accidentally intrude into the personal dwelling of a stranger in a remote or rural location. Now, I would say it is generally unlikely that a person would accidentally intrude into any personal dwelling, but you can see that there's a real focus here on the remote or rural locations. But, they're saying you don't stumble home drunk and go into the wrong house when the wrong house is several kilometers away. However, I think generally the thing of people accidentally intruding into the wrong place is way overblown. That doesn't seem to happen that often. So, and they note, if a person, especially a stranger, enters into an individual's personal dwelling uninvited, this will generally be reasonably perceived by the occupant as threatening in nature. In fact, I think most people would find this to be genuinely terrifying. Not just threatening, but truly something to fear. I think a lot of people who have had their homes broken into, especially when they were home, describe residual feelings of terror. There's often PTSD involved. There is often feelings of people not wanting to go into their own homes. They are no longer comfortable in their homes because now they are afraid in their own homes. And this sort of speaks to the level of fear when somebody comes into your home and potentially is threatening you or the like. They also note there is no affirmative duty to retreat from one's personal dwelling before defending oneself or another person. Case law supports that you don't have to flee your home. They continue on, where it is relevant on the facts, prosecutors must consider the possibility of retreat as part of their analysis under 34(2)(b). Where the possibility of retreat may be at issue, prosecutors must assess whether flight from one's dwelling was a reasonable option for self-preservation or the preservation of others. I would generally say that it's not, but the courts don't always agree. When assessing the reasonableness of the accused's actions, relevant factors to consider include, but are not limited to, the lack of places to effectively take shelter. If you flee outside your house, where are you going? Right? What's the plan? And if you're pursued outside of your house, where are you going that you are better protected than your home? Reduced or limited access to emergency services. If you're fleeing your home, where are you calling the police to? Hey, I need police to running away. Well, they're not coming to running away, but they can come to an address. The accused's reasonable expectation of a timely response from law enforcement. I don't think anybody really can expect law enforcement to show up fast enough to protect yourself from somebody who intends to do you harm. The number of instances where law enforcement shows up sort of in time to stop something is very, very low. Usually they're showing up afterwards. They're doing cleanup. So the presence of unknown factors or threats outside the dwelling during the incident. How do you know you're not running directly to the person's getaway driver or lookout? Something to consider. And the presence of family members, children, elderly persons, or other vulnerable persons within the dwelling at the time of the incident. My wife is not necessarily a vulnerable person in the sense of like a child or an elderly person, but certainly I'm not fleeing my house to leave my wife to fight a burglar. That's not how things are going to go down. I can't see that being ever the reasonable thing to ask me to do, because no, that's just not on. So I think this is reasonable, but I'm gonna add a little caveat here. And that caveat is people are going to say, well, what effects do you think this is going to have? How much do you think this is going to help? And the answer to that is none. I don't think this is going to help at all. And the issues here are going to be, first, that the prosecutors can just kind of ignore this and just go like, well, we think it is in the public interest. Not with, we read the notice. We read the practice protocol. We think we're going to go ahead. And how would they do that? Well, it's not difficult for them to find something to hang their hat on here. They can look right here and they say, prosecution for the use of reasonable force to defend oneself. Well, I mean, if the prosecutor thinks that the force is reasonable, they weren't going to proceed anyway. The problem is that prosecutors often have a very, and other people in society as well, but they often have a very limited idea of what reasonable force is. And so often they will think that force is not reasonable in situations where, for instance, the general public might. There's a reason why self-defense cases are often great cases for a jury rather than a judge if that option is available, because juries are much more willing to see, self-defense and, force being used in self-defense as reasonable than lawyers. And a big part of that is that lawyers tend to live fairly comfortable lives. They tend to be higher income. They tend to not live in bad neighborhoods. And a lot of lawyers, and in turn, judges come from the lawyer pool, also grew up in circumstances like this. And one of the problems is that the bar and the bench, I feel like they just don't know fear well enough, if that makes sense. That they just don't know how terrifying these things can be and how reactions in those circumstances can be maybe not the sort of perfection, and lawyers will repeat endlessly the sort of maxims of you're not expected to weigh force to a nicety in the face of an upraised knife and so forth, but that doesn't stop them from failing to do that in actual practice, in my experience. So I don't think that this is actually going to mean a whole lot. I think that prosecutors are going to look at this and they're going to say, well, okay, but, he shot at the guy who had a crossbow. We don't consider that to be reasonable force because the home invader only had a crossbow or only had a knife or maybe didn't have a weapon at all. But, somebody who I don't see a weapon on is still highly threatening and very terrifying if they're in my house. So, yeah. So ultimately, I think that this is kind of, it's a good flag for her to wave. And you can call this virtue signaling, right? She's saying, I believe in self-defense, in defense of the home and so forth. But functionally, I don't think it's going to do a whole lot. I don't think it's going to offer a whole lot of protection. And I see some people online saying, well, there's going to be people out there who are going to rely on this and they're going to use too much force and they're going to get themselves in trouble. I don't really think that anybody who is in a home invasion ever stops to think about the legal tests. So I don't think that's going to be a consideration. I don't think that's going to be a concern because people in that scenario just aren't stopping to think like, oh, well, what is the precise legal test for the amount of force I can use? They're terrified and they're acting on, monkey brain. And monkey brain doesn't always get it right in the, in the legislation. And to my mind, we need to actually amend the criminal code to recognize that people who are having their home invaded are acting on monkey brain, and that even if they get it wrong, that should really be considered the fault of the home invader. The home invader was the one who had the choice not to have the interaction. The homeowner didn't have that choice. That choice was taken from them by the home invader, who has chosen to prioritize whatever it was they wanted out of the house, which might be money, but it might be to actually assault or murder or sexually assault the homeowners. And you don't know which until, you find out later. So really, if the homeowner goes too far, so long as it's not venturing into something like torture or whatever else, my view is that this should really be viewed as a consequence of the home invader's choice, not something that we impose on the homeowner. But that would require real legislative change. I have suggested proposals to do basically exactly this, but I don't see that they're likely to get implemented because I don't have any power to implement those things. This, I mean, I like the general sort of music that's being played here, but the justice system doesn't dance. It's not going to follow this. Anyway, thank you for watching. I hope you found this to be interesting or educational. A lot of people had questions about this one, and I wanted to sort of organize my thoughts a bit and then share them in this video. So please like this video, share it with your friends, subscribe to see more content like this. I also have a Patreon in the description below, and if you want to support me, that's a great way to do it. I want to thank my Patreon supporters at the $50 level: Bottle Shock and Oz, Canada's National Firearms Association, the Canadian Shooting Sports Association, the Canadian Coalition for Firearms Rights, PJs Forever, Kyle Fox, Angela Skelton, Purple Dragonair, Cielo, Shay B, and Johan/Phoenix, as well as at the $20 level, Drunk All of the Baileys, Mark, Andrew Elsich, Larry Kalniak, Cameron Johnson, and Marvin CZ. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. Hope this has armed you with knowledge. See you next time.